4 major decisions today.
Major court rulings could have a significant impact on gun laws across the country.
4 other states, California, New York, New Jersey, and Maryland, that have similar laws.
Groups like NRA will be ready to meet them at the court steps.
You can't carry it on private property that's open to the public unless you have the permission of the property owner.
Under the Supreme Court's ruling today, would also face being unconstitutional.
Implications for similar laws in other states.
Several states move forward with new firearm restrictions.
The Supreme Court said, nope, you're not going to have that rule. They said that it's too restrictive.
On one ordinary Thursday morning, in the span of just a few minutes, the highest court in the country handed down 4 separate decisions, and by the time the room emptied, the rules had quietly shifted for gun owners, for asylum seekers, for hundreds of thousands of immigrants, and for anyone who has ever thought about taking a giant corporation to court. 3 of those 4 rulings split the justices straight down their ideological fault line, and the cracks they left behind say something much bigger about where this court is heading than any single case ever could. Start with the one that may end up touching the most people in their daily lives because it has almost nothing to do with politics and everything to do with where a person can legally carry a firearm. The case came out of Hawaii, where a state law had taken what most Americans treat as an unwritten rule and flipped it completely upside down. In 45 states, the default works like this. If a person holds a permit and walks into a gas station, a restaurant, or a hardware store, they are allowed to carry their weapon unless the owner specifically tells them not to. Hawaii reversed that. Under its rule, a permit holder could not bring a firearm onto private property that was open to the public unless the owner had first given express permission. Critics gave it a nickname that stuck. They called it the vampire rule because, like a vampire at a doorway, a gun owner had to be invited in first. In a 6-3 decision, the court struck that law down, and the fight inside the ruling is what makes it fascinating because it was not really a fight about guns at all. It was a fight about what kind of right was even on the table. The dissent argued that this was a property question, plain and simple. Property owners have always been allowed to decide who comes onto their land and under what conditions. The argument went, and a state is simply allowed to set the default rule for how that permission works. The majority saw something entirely different to them. The moment a state law tells a citizen they must ask permission before exercising a constitutional right, the whole calculation changes. One justice put the point in a way that lands hard. The country does not make people ask for permission before they speak, and it does not make them ask before they practice their religion. So why, the majority asked, should the right to bear arms be treated as second class? Here's the detail that makes this ruling reach far beyond one island state. The court did not just settle a dispute about Hawaii, it sent a warning to states and to lower courts to stop carving out clever exceptions to the Second Amendment. And that matters enormously because Hawaii was not alone. Similar laws were on the books or in the works in California, New York, New Jersey, and Maryland. So a decision that began as a narrow question about gas stations and storefronts could quietly unravel an entire category of gun regulation across the country. Now, before anyone assumes every restriction has vanished, it has not. There is older language from the court's landmark 2022 decision that still allows states to treat so-called sensitive places differently. Schools, hospitals, government buildings, those remain a separate conversation. But ordinary private property held open to the public is not a sensitive place. And that is exactly the distinction that just got drawn in permanent ink. From there, the court turned to immigration. And this is where the stakes get measured in human lives rather than legal theory. The first ruling clears the way for the administration to end temporary protected status for people from Haiti and Syria, a number that lands somewhere around 350,000 people. Temporary protected status is the program that lets citizens of certain countries stay legally in the United States when their home nation is judged too dangerous to return to, whether because of war or disaster. For the people who depend on it, losing it does not mean a small inconvenience. It can mean reverting to unlawful status, losing a job, and facing removal. In some cases back to countries the government itself still warns Americans never to visit. But notice carefully what the court actually decided, because it is narrower and stranger than the headline suggests. The justices did not rule on whether ending the program was wise, fair, or even handled correctly. They ruled that they were not allowed to ask the question at all. Buried in the statute that created the program is a provision saying courts cannot review this kind of decision. So the power sits entirely with the Secretary of Homeland Security, and that decision is, in the court's own words, simply not reviewable unless someone can mount a constitutional challenge, which is a far steeper hill to climb. In other words, the message from the court was less "this is right" and more "this is not ours to second guess." The second immigration case turns on something that sounds almost philosophical, but carries enormous weight. What does it actually mean to arrive in the United States? The ruling lets the government turn back asylum seekers while they are still on the Mexican side of the southern border, and the entire outcome hinges on two small words. Under the law, once a non-citizen arrives in the country, they can ask for things like asylum. Before that moment, they cannot. So the court had to decide whether standing at the border, looking across, seeking entry, counts as having arrived. The majority said no to arrive. The court ruled means to physically come into the country, not to approach it, not to reach for it, but to actually cross. With those two words narrowly defined, a large number of people lost the ability to even ask for asylum, because in the eyes of the law, they were never quite here. Both of these immigration rulings rest on federal law rather than the Constitution, and that distinction carries a quiet twist, because they are about statutes. Congress could rewrite them tomorrow if it chose to. The court even gestured at that, noting that if people want a different outcome, the path runs through their elected representatives, not the courtroom. Of course, anyone who has watched one of the least active Congresses in history knows exactly how realistic that path is, and it is worth remembering that these are not wins for one administration alone. They are grants of authority that any future president can pick up and use. There is a thread running through all of this that is easy to miss. In case after case, the justices kept returning to the same posture. Do not ask whether we like the result, ask only what the words on the page command. That same logic drove the fourth ruling, the one with a price tag in the billions. The court held by a vote of 7-2 that consumers cannot use state courts to sue a manufacturer for failing to warn about a hazard when the product at the center of it all is the weed killer many people already know by name. Thousands of these failure to warn lawsuits have been filed in state courts. With this decision, that door largely closes. How the court got there is the part worth slowing down for. There is a federal law that gives a federal agency the power to regulate how pesticides are labeled, and that same law says states cannot pile on additional or different labeling requirements. So when someone sued under state law claiming the company should have added a cancer warning, the court found that the state claim collided head-on with the federal rule because the federal regulator had not required that warning in the first place. The question was never whether the product is safe or whether warnings should exist. It was whether one set of rules can override another, and once again the court's answer pointed straight back to the same place. If the public wants warning labels required, Congress can write a new law that says so. So here's the bottom line. 4 rulings in a single morning, a gun law struck down, with ripples heading toward 4 more states, protected status stripped from hundreds of thousands of people, with a courthouse door closed behind them, asylum narrowed to a single definition of one small word, and a flood of lawsuits against a chemical giant shut off at the source. 3 of the 4 broke along the same ideological line, and across nearly all of them the majority kept repeating the same quiet refrain, that the job is to read the law, not to fix it. Whether that is steady restraint or whether it is a choice with very real consequences is the debate that will outlast every one of these cases. And looming just beyond all of it sits the biggest question of the entire term, still unanswered, the one about birthright citizenship, where even now many expect a very different kind of outcome. That's it for today, folks. See you in the next video.